I would have no choice but to give you either a state prison sentence. This would be dismissed, so you would be no admission of guilt. It would be a dismissal on the record. If you could see that, it's a guaranteed dismissal versus I will have no choice but to sentence you to the terms and conditions that are so severe. It's up to you, but I just really want you to consider this because it's very rare that I get a case like this, and I understand the principle of it. I understand that dilemma that you have because you don't, but there's no admission. I rarely see that someone is not accepting this.
All I have left is my soul, and I can't give that up. So it's really a Hobson's choice. There's no choice for me. They say they had DNA, which they never took a sample. It came back negative.
Everything that you read in the paper or in the internet is 99% of the time it's incorrect.
Imagine, you're at your house, you quickly change into your shorts and shirt to exercise in, you drive over to your local jogging track on a bright sun-drenched July early evening. You're not looking your best, but so what? You look good enough and you're not expecting to run into anyone you know. You're minding your own business, successfully doing your fast-walking cardio exercise, never having left the track. You don't notice anyone, and then suddenly you find yourself being questioned by police about what would quickly turn into a felony arrest for crimes alleged to have taken place at the track just minutes before. A non-resident, clearly disoriented, and in violation of local ordinance, had called 911. She explained she was at the bike path, and there had been a man walking the track with himself exposed. Although she correctly states she is in Inglewood Cliffs, she believes she is at Davis Johnson Park, which is located in Tenafly. In actuality, she was at the no bicycle permitted adult asphalt jogging track. The rules were clearly posted. It's not a playground, the judge would later make clear and put on record. A single officer is recorded arriving at the track complex to interview her. Her interview has been secretly taped. She is no longer stating inference about a man having been himself exposed, nothing of the sort. She describes the man's clothing without incident. She makes no other references, having switched to speaking about her own sanity. She does not mention her daughters 6 and 9. She first tells the arriving officer, quote, "I didn't want to go clinical, the pants," end quote.
I didn't want to go clinical, just the pants.
She then tells the officer, quote, "I hope that I'm not a crazy, but," end quote.
I hope that I'm not crazy, but.
She says, quote, "But I don't know. I'd feel terrible if I'm wrong," end quote.
I would also feel terrible if I'm wrong.
The officer leaves the immediate area, and when he returns, she tells him, "I don't have any idea or anything if you're going to find enough evidence," and adds, "I'm very super sensitive about being appropriate."
I don't have any idea or anything if you're ever going to find enough evidence. I'm very super sensitive about being appropriate.
The officer speaking with her had asked her no questions during his entire interview with her at the track as to what she might have seen. Police cam video, taken prior to and at the time a single officer had arrived at the asphalt jogging track, records the woman waiting at the curb. Although she has called police about a man on the jogging track, she is looking in the other direction toward the street. Her daughters are behind her, and the track is behind them.
All right. Let me come out.
Because there is an incline between the track and the curb, only a small portion of the track can be seen. When leaving the area after her interview, still unaware she is being recorded, the children follow her single file to her vehicle. She doesn't look at them, speak to them, comfort them, or herd them into her car as would be typical of any mother who believed her daughters had been distressed. This is consistent with a statement written that same day by Ronald Walt in a police adult arrest report that only references the children as having been present. She agreed to come to headquarters with her 2 children to fill out a statement form. That statement made no mention of her children. The mother has communicated to the police in a multiplicity of ways the strength of her doubts, not the least of which are the words, "I don't know, I'd feel terrible if I'm wrong."
Robert Pentagel, representing Mr. Michael Telzer, with me at council table to my right.
Mr. I understand we are here today for a status.
He's rejected probation, he's rejected PTI.
That's my understanding, because
I understand.
the state's...
What's the sentence? Is there going to be a different plea offer? Your appearances?
Sir, Assistant Prosecutor Kristen DeMarco for the state.
What is the plea offer in this matter?
Your Honor, with regards to this case, the plea offer is non-custodial probation. With regards to any security or surveillance videos in the Englewood Cliffs Police Department, what I can represent, what I told Mr. Pentangelo, is that the detectives from my office that have been trying to obtain all these items of discovery for me, they indicate that they've spoken to the police department and that the videos were not working.
I have some additional information which I shared with council regarding the existence of these surveillance videos, so I need to follow up on that.
What is it that you're seeking? The plea offer is probation?
What I'm seeking, Judge, hope is that I might be able to persuade the state that the case should be dismissed.
What was the plea offer?
Your Honor, it was non-custodial probation. Defendant doesn't have a criminal history, so it's likely, but...
Dealt with time in the county jail? You understand? Do you understand?
He understands.
All right. Report to Judge Slevy.
Thank you, Judge.
All right, Mr. Margot, what case are you here on?
Yes, Your Honor, Michael Telzer, sent over from Judge Roma for a trial date.
My name is Robert Pentangelo. I'm the attorney representing Mr. Michael Telzer, with me at council table to my left.
It's my understanding that defendant does not wish to take any of those options and wishes for trial.
Is that accurate?
That is accurate, Judge.
I don't think I understood the third thing that you said. I couldn't hear you.
If you go to trial and you're convicted, it's mandatory by statute that you have to register as a sex offender, also be evaluated at the Adult Diagnostic Treatment Center, which is called an Avenel evaluation, and you also have parole supervision for life. As opposed to if you accept either the DP, which was what, lewdness, all you would get would be fines and probation. And the DP is not considered a crime, it's considered an offense, a disorderly person's offense. The PTI program is a different kind of program. That program would require you to pay some fines, and then at the end of the program, the charges would be dismissed. So those 2 programs you do not want. You don't want the DP, and you do not want the pretrial intervention program, correct?
No, I will not accept them.
Report here on June 25th, and then we'll tell you what judge is going to be doing your trial. If you fail to appear, your trial will go forward in your absence, and your attorney will be required to be here to represent you. Do you understand?
Yes, I do.
Okay, see you then.
Thank you, Your Honor.
Good afternoon.
Good afternoon to you, too. All right, is this a plea?
Yes, Your Honor.
Okay.
Remains to be seen.
All right, this is Willie Carter.
I'm the attorney representing Mr. Telzer, who's with me at council table to my left.
Okay, Mr. Telzer, we were going to start selecting a jury today, but the jury manager did not bring in enough jurors, so tomorrow she's bringing in 110 jurors. This is because in reviewing the case and getting it ready for trial, I did notice that the charges, if you were to get convicted, are very severe in the sense that I would have no choice but to give you either a state prison sentence or a suspended state prison sentence, but in any event, I have to give you a state prison sentence. The other thing that I noticed is that it's a Megan's Law requirement, and that's for the rest of your life, that you will have to register as a Megan's Law offender, and when I saw the severity of the sentence versus what the potential of a resolution is, which is rather minor. I told your attorney that I would not impose any conditions other than, as part of PTI, there are mandatory fines that you have to pay, and I can't waive them because they're statutory. So it's a total of $125. If you could see that, it's a guaranteed dismissal versus I will have no choice but to sentence you to the terms and conditions that are so severe. It's up to you, but I just really want you to consider this because it's very rare that I get a case like this, and I understand the principle of it. It was something that happened in the public, but you claim it never happened, and I understand that dilemma that you have because you don't. But there's no admission, and I'm sure Mr. Pandelo has explained that to you that this would not be considered as an admission, and it would not be. You told him that it wouldn't be out in the public and all that. He understands.
Yes, Judge, I did explain.
I didn't know if that was the concern. I really didn't know what it was, but it's really. I rarely see that someone is not accepting this, so I just wanted to make sure that you understood the consequences because they're very severe. So.
Judge, I just want to address that very briefly.
Can I make a suggestion? Why don't you just indicate to the judge if you understood what she said, and then if you can either accept the PTI or you can reject it.
I can't do it. I'm innocent of the charges. As far as it getting expunged, it's out there forever on the internet. My reputation in life is destroyed, and all I have left is my soul. And I can't give that up. So it's really a Hobson's choice. There's no choice for me.
I just want to make sure that you understand.
Allegations turn my stomach. They're on the internet. They say they had DNA, which they never took a sample. It came back negative.
Everything that you read in the paper or in the internet is 99% of the time it's incorrect. That's why I tell people that the internet is really the last place for you to go research anything. But
I feel I have no option, Judge.
Okay, we'll see you tomorrow.
Michael Telzer believed the risk was incalculable. He had no knowledge that the McDermott police tape of the woman's interview existed. The only cargo shorts arrest photos the ECPD had sent were so dark as to make the straps on the shorts disappear. Mr. Telzer had no idea that the deputy police chief would months later file a whistleblower lawsuit against his own chief and the entire department that pertained to him. He was going to trial with nothing that could prove he was innocent. With the trial still 2 months away, almost a year later, the terror kept escalating. Judge Roma was still the assigned judge. Attorneys believed in the end he would be the trial judge. Typically, following jury selection, cases returned to the original judge. Roma, having been the judge who appeared annoyed that Mr. Telzer would dare defend himself by trial, having said, "What's the sense?" Michael Telzer kept records of the trial proceedings. In his logbook, he wrote, "It had become a death penalty case for me. I believe Roma will foster a conviction, then send me to state prison, having created a, quote, sex crimes felon, and the inmates will finish the job. I was on record suing the police and refusing every offer. A conviction was the only way they could stop me. I wanted one brave person to stand up and say, 'Enough,' and none of them did. How could I take their walk-away free offer? Most men cannot fight back. I had to try." Michael Telzer noted that he believed the courts had reached the point where they routinely used innocent men as a means of coercion. He believed he was, in effect, being asked to allow himself to become a weapon of the state, so they could, in turn, use him to assist in their perpetuation of hysteria already targeted at innocent women and children. The community I grew up in could not be left to believe there was a monster among them, a fear that would change their lives, their behavior, and their feeling of security forever if left unchallenged. My stolen life is not enough for the merchants of hysteria. They want me to become part of their madness or send me to the inmates. The profoundly sickening imagery of a police headquarters building named in honor of Michael Chiaffi remains in the balance. Michael Chiaffi is the current chief of police. Under oath, She would admit she never made eye contact with the man in question, Mr. Telzer. Asked if Mr. Telzer made eye contact with her, she replied, "Not that I know of." When asked, "Did Mr. Telzer act in any way that would lead you to believe that he was aware of your presence there?" she stated, "We didn't have any contact with each other." Mr. Telzer had never seen or heard of this woman, and in fact had not even noticed her at the track. Asked under oath if she had ever seen Michael Telzer before, she made clear that no, she had not. Asked, "Do you know Michael Telzer at all?" She said no. The police tapes will reveal that the report Officer McDermott called in from the jogging track bore no resemblance to the concerns expressed by the woman he secretly recorded. In her interview, her concerns did not include Mr. Telzer or her children. In Mr. Telzer's civil rights lawsuit, Mr. Telzer puts forth, "As the woman was leaving the track having been asked to go to headquarters to fill out a written statement, Officer McDermott preempts her arrival there by calling his superior by radio, and it is he, McDermott, who has recorded himself as the first to introduce a criminal felony scenario." The officer states, "The daughter saw it too." He takes it upon himself to describe the woman as having claimed that Mr. Telzer's clothing had been in disarray. She said nothing of the sort. The officer introduces the concept of a man exposing himself. There are no accusations of any kind leveled at Mr. Telzer during their entire recording the officer secretly made. None. So secret was the recording, according to court video records, neither the prosecutor nor the grand jury ever knew these exculpatory recordings ever existed.
In light of what discovery items counsel is asking for in 1 through 4, they deal with certain photographs which, in the state's review, certainly seems of no consequence. However, items 2, 3, and 4 are of any type of mobile in-car video, some supplemental report I believe defense believes exists, and if any security or surveillance videos exist. So the state is not aware that any of those items exist. I certainly don't have any of them in discovery, but to the extent that if they do exist and we review them...
My point is, we don't need an April date to do this.
I have those paper, digital copies, color copies, there are approximately 10 of those, and I have a supplemental report. The state is also in receipt of item number 2, which is the mobile in-car video of the police car.
Have you reviewed that tape?
I have, Your Honor. Yes.
What would you represent to be on the tape?
What's represented on the tape is you hear officers speaking to defendant because initially...
Officer McDermott became Sergeant McDermott. Sergeant McDermott became Lieutenant McDermott. The timing of McDermott's first promotion precedes Mr. Telzer's trial by just 13 days. Prior to Mr. Telzer's federal civil rights lawsuit, it had been announced that McDermott was to receive yet another promotion. Michael Telzer was stunned to learn a police official, Deputy Michael McMorrow, filed a lawsuit under the Conscientious Employees Protection Act, also known as the Whistleblower Act. The deputy had interviewed Michael Telzer subsequent to his arrest. The deputy, in July of 2011, according to his own lawsuit, quote, followed proper procedures and correctly concluded that Mr. Telzer had merely been jogging, end quote. Another veteran officer has also sued under the Federal Whistleblowers Act. There had been no DNA. No swab had ever been asked of Mr. Telzer. At the grand jury, under oath, the officer testified in the affirmative when asked, quote, "And to your knowledge, are the results in fact still pending?" End quote. The officer said, referring to the police crime lab, quote, "They are still pending," end quote. The results had been dated October 17, 2011. The grand jury met on October 26, 2011, 9 days after the results had been completed. Mr. Telzer, who is Jewish, albeit not religious, was told almost immediately by his attorney that the woman had been Jewish. When her name was released, a quick search revealed a public Facebook page. Not only was she Jewish, she was Orthodox, citing Congregation Kilath Jeshurun, an Orthodox temple, as her primary favorite on her public page. Her confused phone call that ultimately led to Mr. Telzer's 2011 arrest was on Thursday, July 14th. On Monday, July 11th, the Kilath Jeshurun Orthodox temple was ablaze. By Tuesday, July 12th, terrorism had not yet been ruled out. The New York Times reported 170 firefighters fought the blaze. The terrible fire that would envelop the Kilath Jeshurun synagogue, however, would be eclipsed by perhaps one of the most horrific child crimes the Orthodox Jewish community had ever known. The tragedy, one of the most notorious child crimes in New York City history, began that same day, 3 days prior to Mr. Telzer's arrest.
Monday, July 11th, 2011. It's a date that forever changed this tight-knit Hasidic community.
8-year-old Libby Kretsky. Surveillance video showing him walking down the sidewalk Monday on the way to meet his mom.
Police have arrested a man for a grisly and a horrifying murder in New York City this morning. The body of an 8-year-old boy found cut to pieces in 2 separate locations.
A senseless, violent act. A little boy stolen off the street, his life snuffed out, his body dismembered.
In a crowd of thousands of Orthodox Jewish mourners stood Christians and Muslims, shoulder to shoulder.
I felt like I need to be there. Somehow, someone needs to know that it's not about Jewish community, it's about parents who lost a child.
To comfort the community at this point, or the parents, would be impossible.
We want to begin on a Thursday morning with that chilling confession from the alleged killer of an 8-year-old boy here in New York City.
Libby was Hasidic. His accused killer, an Orthodox Jew.
This was not some stranger who came from somewhere else. Someone from within the community.
Just 2 days after Libby disappeared, thousands of Hasidic Jews from across America gathered in Brooklyn to grieve the devastating and unthinkable loss of one of their own.
The entire world was shocked. What did it do to the community?
First of all, it was a first.
Panic set in. Orthodox Jews worried for the children. On July 13th, the boy was buried. A Jewish man, although not Hasidic but Orthodox, had been arrested. An Orthodox man had killed the Orthodox child, just 8 years old. Rumors circulated. Had there been an accomplice? Had the kidnapped boy been taken to Englewood Cliffs? As it turns out, the boy had been taken to Englewood Cliffs. A service station attendant working in the community had been the last one to see the 8-year-old child alive, also recorded on surveillance video. By any measure, it had been a difficult week. The jogging track is located next to CNBC World Headquarters, which has its entrance on Route 9W. On the other side is the Palisades Parkway. The political party the mayor's father built had been in a steady state of decline, and the son, the current mayor, had been active in a heated re-election campaign. His party had just 2 council seats remaining, and the mayor's newly appointed police chief had been embattled, the subject of an independent external corporate review titled The Matrix Report, one that would prove to be a scathing indictment of the new chief's management of his department. The chief insisted that he needed 8 new officers to add to his force of what had been just 19. Although the borough has always been virtually free of crime, the mayor would campaign as if the community were about to experience a crime wave. Any potential correlation between these events and what happened to Michael Telzer should not be ignored.
When I was first newly on the council, I was a police commissioner. I was appointed a police commissioner. I had a great relationship with the police, and we have the best police department, in the world, in my opinion. These guys are working so hard. We need some help. I've been asking the council for the last 2 years, we need more employees. We need more police officers. Because my biggest fear is, and it's not going to happen on my watch, if something happens to the people of Englewood Cliffs. If a child, I'm not worried about someone coming to my office and pulling a gun on me. In Englewood Cliffs, that happens, or it could happen. Anything could happen. The bad guys are out there, and they got to come through our town some way, and our cops are diligent. I mean, this year alone, even though they're overworked, they're tired, and we need more help, our officers are really working hard getting rid of the bad guys. They're here, they're in our town.
The mayor's party would win re-election, acquiring every open seat in local government. 4 new police recruits had been informally announced to be hired before the council had even been sworn in. Mr. Telzer was arrested and indicted in 2011. By 2012, the force had grown to a staff of 26, a rather sudden increase of 36.8%. Just weeks after Michael Telzer had been exonerated, not only had Officer McDermott been promoted, but a councilman and Parisi devotee who had been the council's longest-serving member actually proposed to challenge the state's Open Public Records Act. He proudly pronounced, "We are going to charge the highest rate in the state," claiming that providing documents and reports about the police department had been a hardship for the borough, a difficult concept considering the officer staff had just increased by nearly 40%. His solution to the number of public record requests had been to make them more difficult to afford. Examining the record of Police Chief Michael Chiaffi. Chiaffi, as a career officer, has been named as defendant in every major police department lawsuit in the last 20 years. Chiaffi has already earned the dubious distinction of calling upon the town to defend him in 4 lawsuits in just over 2 years as chief. Most troubling is his recent testimony in the Stephen Scharf cold case murder trial. Chiaffi's testimony has been disputed by a retired sergeant. Point by point, the sergeant puts forth that Chiaffi's version of events did not happen. The sergeant only agreed that he and Chiaffi moved the dead body and failed to photograph the scene. Chiaffi was investigated after signing an official borough contract that he was not authorized to sign, a contract that was never publicly advertised. When given the opportunity to explain his actions, Chiaffi refused to comment. Borough officials have admitted Chiaffi apparently signed the contract at the direction of the borough administrator, who has since died and is unable to corroborate his story. Chief Chiaffi signed off on a police report regarding Michael Telzer, written by Ronald Walt. Walt had been the officer who interviewed Michael Telzer on that fateful day at the track. McDermott interviewed the woman, however, his recording reveals he left briefly to find Walt, who had been interviewing the man in question, Michael Telzer. McDermott will tell Mr. Telzer, "Well, maybe you should change your appearance." This was, after all, Englewood Cliffs. If the officer thought there had been a crime committed, he certainly wouldn't be concerning himself with how neatly Mr. Telzer had been dressed. McDermott is heard telling Walt that Mr. Telzer is to be charged and what he is to be charged with. Chief Chiaffi offers a press release inferring there had been DNA, yet never takes a sample. He describes a man with his belt unbuckled and with his pants unbuttoned. There had been nothing in the charges to support this claim, nothing of a belt or pants unbuttoned whatsoever. No person, police or otherwise, has ever made an allegation that Mr. Telzer's pants had been unbuttoned. In actuality, Walt would testify that his pants had not been unbuttoned.
If you could just all come into the courtroom and just find a place to stand if there's no more seats. They could sit, some of them could sit there if they like, that's fine. Okay, are they all in from the hallway?
Just about, yeah.
All right, is everybody in from the hallway? You can come around and sit in the chairs here. If everybody could just come on in. Somebody could come here in the middle, this way you have more room. Did everybody come outside? All right, can you close the door for a minute? Can you close the door if that's everybody that's from the outside hallway? Okay, good morning, everyone. My name is Judge Diavila Celebi, and I'm assigned to the Criminal Division. I'm the presiding judge of criminal. And you've been assigned here today because I'm going to be selecting a jury in the case of State of New Jersey versus Michael Telzer. And we're about to begin the process of the voir dire. It means in French to speak the truth. I would like also now to introduce the attorneys, and first for the state.
Thank you, Your Honor. Good morning. My name is Kristen DeMarco. I'm an assistant prosecutor here in Bergen County. I am assigned to the Special Victims Unit, and I represent the state of New Jersey.
And counsel.
Thank you. Good morning. My name is Robert Santangelo. I'm representing Mr. Michael Telzer. Jury as is presently constituted is acceptable to the defendant.
I spoke to the judge who's going to, you were assigned to me to select the jury, but now you're going to the trial judge who's actually going to do the trial.
A remarkable turn of events. The Honorable James J. Guida was designated to be the trial judge. Judge Roma was no longer assigned to the case. The Honorable James J. Guida tried Michael Telzer's case. The state had 3 witnesses, 2 officers, and the woman. Judge Guida instructed the jury as to the credibility of the state's witnesses. The judge charged previous contradictory statements of witnesses, false in one, false in all, multiple charges, and substantive charges. Regarding the woman, Judge Guida would later charge and instruct the jury as per her inconsistencies, noting, "The extent to which such inconsistencies and omissions reflect the truth is for you to determine." Regarding the defendant, Michael Telzer, the judge instructed the jury to consider if there exists a reasonable doubt of his guilt, even though that doubt may arise merely from his previous good repute, he is entitled to an acquittal.
I hope that I'm not crazy, but I would also feel terrible if I'm wrong.
Well, you should change appearance.
He's rejected probation, he's rejected PTI.
That's my understanding, because
I understand.
the
Then
state's...
what's the sense?
It's very rare that I get a case like this, and I understand the principle of it.
My biggest fear is, and it's not going to happen on my watch, if something happens to the people of Englewood Cliffs. The bad guys are out there, and they got to come through our town some way.
The borough of Englewood Cliffs is taking the position Mr. Telzer was not damaged and did not suffer trauma, and his claim is frivolous. Nevertheless, in the last 2 years, Mayor Parisi's party, against the objection of the opposition, went ahead and has indemnified the police chief, the officers, and most recently themselves. Parisi admits it was introduced with the police chief. Parisi is quoted as admitting he was, quote, defending the measure as providing protection for municipal officials who might be victimized by overzealous judges and juries, end quote. The mayor's distrust for judges and juries apparently has no bounds. Indemnification would be retroactive and apply to named defendants in existing cases against the borough, the mayor included. The opposition party did not vote in favor of the ordinance. The taxpayer would pay such damages. The purpose of the ordinance is to protect those accused or convicted of egregious misconduct. Chief Chiaffi, along with officers Morrissey, McDermott, and Walt, remain active members of the department. The men have yet to be charged with the crime, disciplined, or investigated.